Okay, so this week we're on chapter 4 if you're following along in a text, but we're also going to be looking at the Blue Book, which is the Law Enforcement Officer's Handbook, specifically chapter 2 and chapter 4. So a few items that I want to go over within chapter 2 is one, the chapter is general code provisions. And really pay attention to the culpable mental states. Start following those along. Most of your criminal charges are probably going to fall under knowingly. So you'll want to pay particular attention to that as you read through the chapters. Also, look at ignorance and a mistake. That kind of falls in with what we're working on this week. Looking at, if somebody makes a mistake as far as a crime, is it a factual or legal impossibility? That would kind of fall in with that. And then accountability for another. There are certain criminal acts that you are accountable for the behaviors of another person. I want you to pay attention to the defenses, especially entrapment. You're going to hear that entrapment quite a bit if you go into a law enforcement career. And what people think it is and what it truthfully is sometimes different. So, and then knowing the definition of duress. If there is a defense as far as intoxicated or drug condition, most of the time there's not. So you're going to want to look at that. Chapter 2 is relatively small. And then chapter 4, when we start looking at inchoate offenses, is actually smaller. We're only talking about 3 pages for chapter 4. What you're really going to notice in the text as we go along and we start looking at inchoate offenses, we're looking at attempt, conspiracy, and solicitation. Now, Missouri chapters, there is no solicitation, but if you will look under substantial step, there's where you see the solicitation fall under that. So when we start looking at something as far as soliciting somebody else to commit a crime under Missouri statute, there's where it's going to fall. And it's not necessarily going to be specifically mentioned in the actual RSMO, but it is right here in your Blue Book. Okay, keeping going, I want to look at our definitions, just because sometimes we forget on these particular offenses that inchoate is just begun, so it's not fully formed or developed rudimentary. That's what the actual definition is. So we are just in our anticipatory stages as far as the crimes. And that kind of falls under preliminary, anticipatory, or inchoate crimes. Solicitation or enticement crimes, attempt to get another to commit a crime. Conspiracy crimes, which is an agreement. Wharton rule, when we start looking at rules as they're going to be something made by the courts. Attempt crimes, acts that are a substantial step, so like attempted burglary, somebody goes up and they're trying to make entry into the house, but they don't actually get the job done. Parties to the crime, accomplice, one who aids another, aider or better, because this is an after effect most of the time. A conspirator or co-conspirator, and then common design or plan. The rule of what they did, they all did, or excuse me, what one did, they all did, that everybody involved in it is just as guilty as the one that did it. Pinkerton rule, federal courts that no one conspirator is liable for crimes committed by another conspirator if foreseeable and done in furtherance of the conspiracy. So we'll look at that a little further as we get into our lecture. And then post-crimes offenses, so this is after the crime has taken place. The chapters that we're looking at this week come from chapter 562. And if we're looking at RSMO, chapter 562, it goes through our voluntary act, attempt, conspiracy. Again, you're not going to see solicitation in there. And it mentions our culpable mental states. So this basically falls right in with chapters 2 and chapters 4 of the Blue Book. And then here are our entrapment, duress, intoxication. There's also a defense as far as lack of responsibility because of mental disease or defect. So that is one that you definitely want to look at. So criminal liability, as far as the stages of committing a crime, we can get criminal liability at the time that we start planning something out. Now, you just thinking about a crime, that's not going to be a crime itself. We probably have thought about doing something, but that's as far as it ever went, just thinking about it. What we have to start looking at is when we start making plans, start following up on that, maybe start even doing research on it. So let's say that you're going to commit a robbery. That just comes to your mind one day, and you start researching a little bit more, and then you start planning a little more, and then you start drawing up instructions to yourself on how you're going to do this. Well, you're crossing that line when it comes to the point that you're making substantial steps towards the commission of that act. And you can fall back and say, well, I was just looking. And that may help you. And then again, depending on what the crime is and how far you went, it may not. So when we're looking at as far as the origins of a criminal plan, again, thoughts alone are not going to be chargeable. But at the time we start planning and preparation, then we start looking at those inchoate offenses. So solicitation, conspiracy, what are we looking at here? And then we attempt the crime. So maybe we don't get all the way to it. We're on our way to rob a bank. We've got our getaway car, our hoods, our weapons, and everything else. And then on the way to the bank, the car breaks down. Law enforcement pulls up. What are you doing? We were going to go rob a bank. Well, in reality, you never got to the bank, but you definitely conspired and got that attempt there. Then the actual commission of the crime, if we get that far, and then if there's any post-crime. So post-crimes, again, think about resisting arrest, harboring or aiding a felon, lying in court, so perjury. So your intent to commit a crime, what are we looking at? Again, fall back to your culpable mental states when we look at that. It is possible to commit a crime basing on a joke. With what's going on in our nation right now, if you were to walk into an airport and, even make a joke that there may be some kind of improvised device that could be a threat to other people, you're definitely going to get yourself in trouble under 18 USC, which stands for United States Code. So, and then liability. There's where we fall into where you become responsible. So the word liability just means you are responsible at some point when you ask somebody to be involved in a crime or to commit a crime, when you work with somebody to commit a crime, or you actually attempt the crime whether you complete it or not. So these are called preliminary anticipatory crimes. The words that you will hear a lot as you go through your careers are those inchoate offenses. So when we start looking at inchoate, we start looking at where and when does non-criminal conduct become criminal, and we looked at that earlier. Which of the preliminary offenses, if any, has the suspect committed? So let's say we're planning a burglary and we know we have to make entry, so we start gathering tools. Well, the second we start gathering tools, we are looking at actually a separate charge of possession of burglary tools, no matter if the tools would be used in everyday life or not. When does the commission of the principal offense begin? So as to allow the state to charge either the preliminary offense or the actual offense. So solicitation, again, like we've talked about before, you're not going to find this in RSMO. You will find it in an explanation. So solicitation is a crime to get another person to commit a crime. Now you can read the prostitution statutes, specifically RSMO 567.020, which is prostitution. And part of that is engages or offers or agrees to engage. Now this could be looked at upon as solicitation, but it doesn't specifically mention that word there. So solicitation doesn't have to be successful. It's just that offer was there, and that's what we're going to look at as far as committing that criminal act. So why do we have solicitation statutes? One, to prevent crime, protect public from criminal inducement, so we don't want the criminals out there trying to get other people involved, and permit society to identify and deal with persons who show that they are dangerous. So conspiracy crimes are agreements between two or more persons, and it's one of our oldest preliminary offenses. So preliminary, again, just being before the actual crime's committed. We can have conspiracy can be proved even if the co-conspirator can't be found, identified, or died. So used to we had to have two people, now we don't necessarily have to. So one of them can form a conspiracy, the other party disappear, pass away, and as long as we've got the evidence to show that there was an actual conspiracy, we can still charge that single person. So all states have conspiracy statutes to increase potential harm to society as far as stopping that, reduce the possibility of abandonment of the crime, just increase the chances of success of the crime. And one, we look at that, can we make it more difficult to commit the crimes if we can stop people from conspiring to commit truly heinous crimes? So as far as two guilty people, we mentioned that just a second ago. The old bilateral agreement required two people to both have a guilty mind. Now it's unilateral. So when we look at this, an approach to the crime of conspiracy that does not require actual agreement between two or more persons, under the unilateral approach, when an individual agrees with an undercover agent who has no intent to commit the crime, there can still be conviction for conspiracy. So someone goes out and they're working with an undercover officer, obviously they don't know that, and they think they're conspiring to commit a criminal act. In reality, they can be charged with the conspiracy, but their actual crime's not committed. So partnerships, conspiracy statutes designed to prevent criminal partnerships. Because conspiracy was looked on as a partnership in crime, traditional view, again, a bilateral approach, we've changed that to that unilateral approach. So the existence of two people, husband and wife, can satisfy two or more persons. State versus Bass is that case, if you wish to look that up. And corporations conspire, but two people have to conspire. So Corporation A and the CEO of Corporation A cannot be convicted of conspiracy. We have to have two people in the corporation to actually have the conspiracy. So overt act, when we start thinking about that, you're going to see substantial step in the words overt act. When we start looking at those and talking about it, we look at something that shows this person is going to do this. So, evidence of an overt act would provide some assurance that at least one of the conspirators is sincere. So if somebody says, hey, I'm going to go injure this person, and the other person says, yeah, I'm going with you, and nothing ever follows up besides that, we don't have anything. But let's say one of them goes and says, hey, I've got a stick in a closet, and I'll go get the stick. Now at that point, we're showing that they're taking steps, which is that overt act, to commit that crime. So today, most states require proof of an overt act by the defendant. In fact, if you start reading our statutes, you will see that in those. So RICO is racketeering, influenced, and corrupt organizations. Basically, you're responsible for what you order and instruct for others to do. Where this worked around is the mob. This goes after the bosses for what they order their people to do. Whitfield, the United States, some statutes do not require an overt act, but only agreement to participate. Overt acts are often very convincing evidence of sincerity of the conspirators. So again, we want to know that one of these people actually means this, and they're not just making comments. So Wharton rule, some crimes cannot be committed alone, but require two or more people. If that's the case, the conspiracy is not totally charged. So gambling, prostitution, receiving a bribe, distribution of illegal drugs. So two people are distributing drugs. They have to work with that third party to be able to do that. So again, here's the example. Distribute illegal drugs. There must be both the deliverer and a person receiving the drugs. Under the Wharton rule, if two persons engage in a one-time sale of a small quantity of illegal drugs, the seller and the buyer cannot be charged with a conspiracy. They're going to be charged with the possession or distribution, depending on how that state statute goes. So abandonment, what abandonment means is, when we're talking here, is abandonment of the crime, or stop. We're not going to do the crime. So a person can change their mind. So depending on how far they're gone, abandonment or withdrawal by a conspirator makes the crime nonetheless complete if they go too far. We have to ask certain questions. Has a preliminary crime been committed? So have they gone out and said they were going to do a robbery and they've already got the mask, they've already got the gun, planned their escape route? Or was it just in the thought process? Was it voluntary or involuntary? So we've got somebody that was going to mug somebody, and as they came up, somebody started screaming or fought them off. So they didn't abandon the crime, they were just thwarted in their effort. And then why did they look at the abandonment? So they plan a burglary, they get to their location and realize that there's cameras and other security at the store, so they don't actually go through. They still conspired, they still took substantial steps. So impossibility, abandonment, withdrawal. In this court case, the Ninth Circuit Court of Appeals decision that conspirators could not be convicted of the crime if the object of the conspiracy had been defeated. So that's the case right there if you want to look that one up. Defendants argued that since the object of the conspiracy, possession of illegal drugs, was made impossible by the seizure of the police, the conspiracy was over. The court said no. You worked at it, the police thwarted you as far as the drugs go, but it was your agreement to commit the crime, not the crime being committed, is what they're being charged with. So again, abandonment, withdrawal, even the conspiracy is abandoned, or one conspirator withdraws, the crime of conspiracy is nonetheless complete. Since the crime is complete with the agreement, no subsequent actions can exonerate the conspirator of that crime. So, however, if one conspirator withdraws from the conspiracy outside the limitation period for prosecution, so statute of limitations is what we're looking at there, the withdrawal bars conviction. One of the things when we start looking at statutes is when the person withdrew, how far did they go to stop that crime? So did they immediately need to notify law enforcement? How did they go about that? So when we read our statutes. Okay, again, crime of attempt. So the crime of attempt is the most frequently charged of the three preliminary crimes because the near victim and witness generally report attempted rapes, robberies, murders, etc. Even if the crime was not actually carried out, an attempt poses criminal liability. And you can see that from Chapter 4 of your Blue Book. So intent does play a role in attempted crimes. Where the base crime is specific intent, attempt must have the same intent. So simple possession of burglary tools is not enough for the crime of attempted burglary, which requires proof that the person intended to enter a building. So they could say that, I'm going to use these tools to commit a burglary, and that you definitely have possession of burglary tools, but no attempted burglary because they haven't have a specific spot picked yet. So strict liability crimes, however, punish forbidden acts without intent, so selling contaminated food. So these would be regulatory crimes, and we talked about those in previous chapters. So substantial step. Federal courts, many states use the Model Penal Code substantial step test. And if you will look at that back in Chapter 4 of your Blue Book, there is an excellent listing there of what a substantial step is. So, but for our purposes, a substantial step, a person is guilty of an attempt to commit a crime with intent to commit a crime if they engage in conducts which tends to affect the commission. So gathering addresses of witnesses, arranging for finances for a hitman, sending the letter, whatever they did that would say, okay, this person's going to actually commit this criminal act if they're not stopped. So impossibility, we have a factual impossibility. So somebody goes out and tries to pickpocket a person and they find the one person with nothing in their pockets. They still tried to do the stealing from person. So the attempt of the pickpocket didn't necessarily matter. Legal impossibility, this is attempting to receive stolen goods that were not stolen. So somebody says, hey, I've got something that makes you believe they're stolen and they're going to give them to you at a really good price and you buy them. Even though they said that they thought they were stolen, if they weren't, we can't charge them with that. So most courts reject any defense based on factual reason why the attempt could not be successful. So, if I say I couldn't have done the robbery because my gun wasn't loaded or the drugs were fake, that's not necessarily going to be a defense for us. Most courts agree that it's still an attempt if the circumstances were as the person believed them to be. So it typically does not matter if the conspirators change their mind, which is abandonment or withdrawal. Conspiracy crime is complete when the criminal agreement is reached. So when we get down to the actual planning of that crime and we come to a point where we have an agreement, we are in that conspiracy realm. So parties to the crime. So parties in the first degree, the person who actually commits the crime. Second degree, known as the persons who were present at the commission of the crime. So this may be the getaway driver or something like that. Aider, abettor, or conspirator. Obviously, we've talked about a conspirator. That's the person that you planned it out with. somebody that may have supplied tools would be an abettor, and then or an aider, and these two may be after the fact. So, you know, somebody is involved in a homicide and they bring the weapon, the bloody clothes, and everything else to another person, and they dispose of those items. They would be an aider and abettor, or a person after the fact involved in that crime. So, accessory before the fact, person who knowing that a crime was to be committed, aided in the preparation. After the fact, like we just talked about, knew that the crime had been committed and gave aid or comfort, or basically helped. Neither an accessory before the fact nor an accessory after the fact could be tried until after the conviction of the person that actually committed that crime. So, parties to criminal liability, what one did, they all did. The rule that all parties in a conspiracy or the agreement to perform a lawful act are liable for every action, no matter what they did. So, defendant Watts guarded the parents of a teenage girl while his two friends raped the girl. Watts is convicted of 2 counts of rape too. So, they are responsible for the conduct of another. And you should read that in Chapter 2 as far as the examples there. So, under the common design rule, when people have a common plan to do an unlawful act, whatever is done in furtherance of that common design or plan is the act of all of them. So everyone can be punished for what one did if they all are involved in that planning and the substantial steps taken in the commission of the act. So Pinkerton, co-conspirator can be held liable for crimes committed by another conspirator, even if the co-conspirator did not know about the commission of the crime. So persons can be guilty of unforeseen acts during the commission of a crime. Post-crime offenses, these are as far as post-crime offenses that we would look at in RSMO, obstructing justice, false report, misprision of a felony. This is basically failure to report a known felon, depending on what the statute is, harboring or aiding felons, communicating with jurors with intent to influence them. So, designed to assist in function of smooth criminal justice system, we do not want people being involved in a way that's going to take away from our courts and other justice system procedures that would ensure a fair outcome to everyone involved. So that's the end of this chapter. I would go through this again. Definitely read chapters 2 and chapter 4 of your blue book. They are extremely interesting. They're not very long, and you should be very familiar with them. If you want to look at RSMO, this is the chapter that we've covered a lot of. It's 562, and you can start clicking on these and read through these. Definitely something that you should know how to get to, especially if you're going to go into law enforcement. So that is it for this week, and we will start again with Chapter 5.